shot queen of the plot. Hit that bell, cause the tea don't stop. She don't miss nothing.
Hey guys, how is everybody doing now? I told y'all that I wanted to get into the video. I hope y'all can hear me because I got a standing table and I didn't want to sit down, so I'm standing up. So I had told y'all that, you know, when I was in court, I got a whole bunch of videos. As a matter of fact, let me look on my, because I actually call myself, I had gotten a different phone because it was so hard to do it with these, you know, one phone. 1, 2, 3, 4, 5, 6, 7, 8, 9. I got like 13 videos. So what I did was I broke the videos down. And hi everybody, if I didn't say hi, hello. I broke the videos down because what you'll learn is they're in different segments. So what I'm gonna, you know, show you guys right now is the opening statements. What you're gonna hear is you're going to hear Porsha's attorney give his, you know, opening remarks. You're also going to hear the judge. Now, let me kind of make you, you know, kind of remind y'all of what's going on. So, the purpose of the prenuptial agreement is simply for one purpose only. They don't have to go to court. You know, you get divorced, you have to go to court, and then the judge decides who gets what. So the purpose of the prenup is simply for that purpose. No judge does not need to decide anything because guess what? The prenup already says it. So hi, Danielle Harris. So that's the reason for the prenup. Okay. So I just want to kind of bring that back to kind of, you know, refresh y'all memory. So the whole purpose of the court hearing was because Porsha said, I want you to enforce the prenup because we, you know, we already have a prenup. Why are we in court? And also, let's not forget this because I think I kind of forgot about it too. In the prenuptial agreement, Simon actually agreed to give her these things, but somewhere along the line, he changed his mind because there were other factors, which actually he had good merit because what I did learn is in the prenuptial agreement, there was actually language that stated if you did this, like for instance, it said that Porsha could not film in the home. Now, the prenuptial agreement said that in order for Porsha to film in the home, she needed to get Simon's approval. Now, I want y'all to keep that at the forefront of y'all mind because the prenuptial agreement is being enforced. But is it really being enforced? Because one of the things it said is that Porsha could not film in that house. I mean, obviously, if she's able to refinance it, then it becomes her house. But the prenuptial agreement said Porsha could not film in the home. It also said that Porsha cannot discuss anything with regards to their marriage, and you know, anything, you know, with regards to like the division of property. So I just want y'all to understand. So what I did yesterday is I just kind of let y'all know what happened at court. I wasn't able to show y'all the video because some of the video had stuff in it that I would have to take out. So I'm going to get the video up, y'all. So what I'm going to do is I'm going to play these two. This is kind of what happened right before lunch. What's wrong with this thing? It ain't moving. Wait a minute, y'all. Now, what's going on? Been acting crazy all day. I've been trying to get on here and StreamYard has been BSing. I'm gonna go with another service provider. Let me get these back up, y'all, because I don't know what just happened. So I'm gonna get the videos up. I'm gonna have to. Why is it not?
Arguments.
Let me stop it right now because I gotta actually upload them all over again.
4 or 5 minutes.
Okay. So what I'm gonna do is we're gonna start with the first video, y'all.
Regarding the motion in force, so I'm I'm not going to be shy as if I've heard enough on a particular topic. Given the fact that it's a motion to enforce, I guess we'll address the motion to enforce, and depending on what my ruling is there, then we can move into the actual divorce proceedings. Is there anything else before we go forward?
Yes, Judge. I'm sorry.
Mr. Kessler said no, so Ms. Ferry, what do you have?
Okay. Judge, I was going to ask, since the court is, based on the ruling, and based on, it seems like what the court's position is regarding contracts, one thing, again, Judge, that I requested during my discovery was copies of any and all contracts. At this point, it's like my hands are tied, Judge, because Mr. Kessler has proffered to the court that he plans to ask about contracts and get into contracts.
Objection, I did not.
Well, wait a minute, there's no need to object on this, but you can respond to it, Mr. Kessler. She's just making an argument here, but go ahead, Ms. Ferry.
Yes, Judge. So the need for the contract is certainly crucial because the contracts that Ms. Williams has signed or executed as it relates to her employment certainly weigh in on the issue of whether or not the prenuptial agreement is enforceable or not. Certainly we believe that those contracts that she signed and entered into were in direct or are in direct violation of the prenuptial agreement. Not only that, those contracts are relevant to the issue of her income, especially whether there's been any changes, substantial changes from the last, November 2022, when the parties entered into the prenuptial agreement. The court must determine whether or not there's been any changes in her financial circumstances or status that will render the contract unfair, essentially. And what is crucial to that is having those agreements from Ms. Williams. The court mentioned I know the court is calling it the quote discovery waiver, and I'm putting air quotes around it because I know that appears in the order that the court entered. As far as the discovery waiver, Judge, my understanding of the order, well, one, there is no
makes sense. I don't know why StreamYard keeps cutting the video off. Y'all, I am so sorry. I am so over StreamYard. This don't even make no sense.
Circular arguments regarding the motion to enforce, so I'm not going to be shy as if I've heard enough on a particular topic. Given the fact that it's a motion to enforce, I guess we'll address the motion to enforce, and depending on what my ruling is there, then we can move into the actual divorce proceedings. Is there anything else before we go forward?
Yes, Judge. I'm sorry.
Mr. Kessler said no, so Ms. Ferry, what do you have?
Okay. Judge, I was going to ask, since the court is, based on the ruling, and based on, it seems like what the court's position is regarding contracts, one thing, again, Judge, that I requested during my discovery was copies of any and all contracts. At this point, it's like my hands are tied, Judge, because Mr. Kessler has proffered to the court that he plans to ask about contracts and get into contracts.
Objection, I did not.
Well, wait a minute, there's no need to object on this, but you can respond to it, Mr. Kessler. She's just making an argument here, but go ahead, Ms. Ferry.
Yes, Judge. So the need for the contract is certainly crucial because the contracts that Ms. Williams has signed or executed as it relates to her employment certainly weigh in on the issue of whether or not the prenuptial agreement is enforceable or not. Certainly we believe that those contracts that she signed and entered into were in direct or are in direct violation of the prenuptial agreement. Not only that, those contracts are relevant to the issue of her income, especially whether there's been any changes, substantial changes from the last, November 2022, when the parties entered into the prenuptial agreement. The court must determine whether or not there's been any changes in her financial circumstances or status that will render the contract unfair, essentially. And what is crucial to that is having those agreements from Ms. Williams. The court mentioned that I know the court is calling it, quote, discovery waiver, and I'm putting air quotes around it because I know that appears in the order that the court entered. As far as the discovery waiver, Judge, my understanding of the order, well, one, there is no express discovery waiver in the prenuptial agreement. But nonetheless, my understanding of the order was that Ms. Williams could not be compelled to respond to my discovery request. It doesn't mean that my hands are tied when it relates to presenting any other evidence or information. It just indicates she didn't have to respond to my subpoena request, didn't have to appear to a deposition, did not have to produce certain documents. And so I would ask the court to, at a minimum, to allow fair access to those contracts that were mentioned by Mr. Kessler between Ms. Williams and her employers.
Well, I'm going to let Mr. Kessler respond, but I do want to put the parties on notice again, and and you were discussing that nuance a minute ago, Ms. Ferry, but I made my order. I obviously you disagreed with that order, and I tried to carefully balance what you had, you know, a carefully constructed prenuptial agreement that took into account the needs for confidentiality of the parties, and you know, my order speaks for itself. And so what I don't want to happen today is just another hearing that we had, another discovery hearing that we're going to have, except put a 2.0 next to it. We're just going to have all the same arguments, the same discussions again, because my ruling does stand. But I, you know, as far as documents that you already have in your possession, I'll let Mr. Kessler speak to that in his response. Go ahead, Mr. Kessler.
I think Your Honor gave my response for me.
I apologize for that.
No, that's fine. That's the best thing that could happen to us. Whatever I said was colloquy. I don't know. I'm not saying there's contracts that she doesn't want to provide or anything like that. Something's going on with my computer. I don't know what's going on with my am I still on Zoom? Okay.
I can hear you loud.
I'm not hiding the ball. There's no contracts. My point was to clarify for the record, for Ms. Ferry, and for the record, if they're going to appeal, I'm not suggesting there were any contracts that she hasn't disclosed or anything like that. I was talking generally when financial terms come up, relationships, negotiations. It was part of my argument as to why it shouldn't be recorded. I was not, certainly we're not hiding the ball, but I'll move into my opening. I think the court's already ruled, so I'm happy to do my opening.
Okay. Let's go ahead and Ms. Ferry, we'll, as I instructed Mr. Kessler, we'll take your, sort of the issues that you brought up in that argument you gave, we'll take them as we go along if you've got a specific document or issue. But I've made my ruling. I know you disagree with it, but as far as Ms. Williams needing to turn documents over. Go ahead, Mr. Kessler, with your opening.
Well, give my opening. I also want to preempt one thing that I'm anticipating from Ms. Ferry. I'm anticipating in her opening, she's going to say that our client has talked about Mr. Guobadia publicly and they're going to introduce this information. I'm going to ask that she be precluded from doing that. It's not until we get to that point in time. Your Honors said reserve my arguments, but I don't want her getting it in through opening statement when I anticipate her argument is going to be, as she put in her filing and her amendment to the response to the motion to enforce, she said because our client has talked about the divorce publicly, then the prenuptial agreement shouldn't be enforced. And I want to preclude that for 5 reasons. One is he talked about the divorce first publicly. 2, if she is doing that, she's saying that.
Well, I guess, Mr. Kessler, it's your opening. I don't mean to cut you off, but I don't know why that's something you would deny her on her opening. I mean, isn't that argument that you're just going to make during the case?
I don't want her to even enter that arena when she's to be even able to make the argument that our client has violated the prenuptial agreement, so therefore it shouldn't be enforced.
Well, but there's no jury in this trial. I realize there's concerns now that there's a podcaster here, but there's no jury, and I'm not going to limit her opening in that matter. But go ahead.
Okay, I'll just make it part of my opening that conceptually speaking, their argument against the prenuptial agreement, now this newest one, is that our client violated the prenuptial agreement, so therefore it shouldn't be enforced, and that's backwards. Does that mean they want the prenup enforced so that they can enforce that provision of the prenup that says they shouldn't talk about it? And if so, then what about all of his violations? So we can get into all of his violations of it if we need to, Your Honor, but certainly that argument, and again, when you're moving to enforce the prenup, I think we've already proved that the prenuptial agreement is enforceable. Your Honors has considered, I think, almost every evidence that's relevant and needed to enforce it in our last hearing, and I'm glad Your Honor has the ability to consider every piece of evidence. I want to make sure that we have tendered the transcript of that hearing, and we'll ask that it be admitted under pace to be pace, including the transcript of the testimony of Ned Bates, the probably best known, most renowned scholarly expert on prenuptial agreements in Georgia, who has testified clearly this is probably the most enforceable prenup he's ever seen. That how long does it take to negotiate so that you have full disclosure? What's the longest negotiation period you've ever seen? He said 1 year. I'm not going to recap the entirety of the hearing, but this is my opening. He was the one who handled share versus share. He was involved in all of the cases, almost all of the cases cited by Ms. Ferry in their response and their objection to enforcing the prenuptial agreement. And he has testified clearly, and he's here to testify again today, that he believes in his opinion. He's the one who wrote the original Forms book on family law, including prenuptial agreements that every lawyer used for at least the first 20 years of my practice. And he thinks it's enforceable. In fact, the person who wrote it on behalf of Mr. Guobadia was in his firm for years. Ted Atrum and Alice Cutler were under his tutelage years ago. So let me briefly run through a timeline of where we are, because part of enforcing the prenup is that we're also asking Your Honor to award our client $250,000 in attorney's fees today, or at least $225,000, because her entirety of fees, Ms. Hayward James will testify, has been $250,000 after today, and $225,000 of those is directly related to the violations set forth specifically in the prenuptial agreement, which quote exactly what should be sanctioned. Any activity whatsoever related to objecting to the prenuptial agreement. I just want to read one quick portion there. This prenuptial agreement says, if the agreement is ultimately enforced, I'm reading from page 18 of the prenuptial agreement, the party who opposed such enforcement or adoption of this agreement shall pay the other party 100% of the attorney's fees, litigation expenses, expert expenses, and costs the other party incurred responding to, defending against, or opposing such efforts to contest, challenge, or oppose the enforcement of or adoption of this agreement. Efforts to contest, challenge, or oppose the enforcement or adoption of this agreement shall include, but are not limited to, the following. And Your Honor, it goes on, Your Honor has it in front of you, but it includes every single thing that they have done. Opposing any request or motion to the court or tribunal to enforce this agreement, which is what they're doing today, or to have this agreement incorporated into any final order of such court, etc. Refusing to consent to the enforcement or adoption of this agreement in connection with any action for divorce. That's number 2. Asking for hearings on it, taking any other action.
What page is this on again?
Page 18 of the prenuptial agreement.
All right. I know it's your opening, but I have it in front of me.
Yeah, and I would actually just, I've never seen one so comprehensive, describing every single thing that they've done. Taking any, and the catch-all, taking any other action, the purpose of which is to prevent or oppose the enforcement of this agreement by any court or tribunal. And because Your Honor has this, you can read it. I'm going to not read it further. And I just want to remind the court of where we are, because this case has gone on as long as the parties were married, and I want to run through my quick timeline so that I don't forget. I'm going to share it with the court, with the court's convenience. I'll just run through it quickly. It's shorter than me reading from it, so if I may. The timeline of this divorce, it started November 21. They began negotiating their prenuptial agreement. He hired a lawyer, and his lawyer drafted the initial version. Alex Cutler, Ted Intrum. It was dated a year later, November 2022. It was signed on November 17, 2022. But there were email exchanges that we will put into evidence, and I think Your Honor already has them in evidence, that for about a year they were going back and forth negotiating, disclosing, talking about it. They got married November 26, 2022. She filed for divorce February 22nd, 2024. And I want to remind the court that she gets $40,000 a month in alimony for each month they were married. She hired us on February 21st or 22nd. Had she waited until February 26th, Your Honor can do the math, she would have gotten another $40,000 in alimony, another month's worth. She determined not to do that. She wanted to get the divorce moving for a lot of reasons that, if relevant, she can explain. I don't know that she needs to, but the point is, it was not about staying in longer when everyone says, or there's accusations by opposing counsel or her husband that she's just doing this for money. She would have been much wealthier had she stayed married to him for another few years. $40,000 a month could add up very quickly if she stayed another year, 2, 5, 6, 10. She didn't do that. After we filed, they acknowledged service. They acknowledged the agreement. They sent an email saying that he will do what the prenuptial agreement says. And the prenuptial agreement says that he will vacate within 30 days. His lawyer said, okay, he will vacate within 30 days. He asked for an extension, and our client said no. Please vacate within 30 days. She's got a child, she wants to be in the house. My understanding, he might have been out of the country already. Anyway, but he then blocked her access. Twice he changed the locks. Twice she had to come back with locksmiths and get access to the house she was living in. Then she had to file an emergency motion. And all these are actions that were necessitated because he did not agree to follow the prenup or to the enforcement of the prenup. She filed a motion. He filed a motion for temporary possession of the house, directly contrary to the prenup. We had to file responses to those motions. He filed a counterclaim disputing the enforceability of the prenuptial agreement. He filed tons of discovery. He subpoenaed her employer. We filed a reply to his answer. He opposed the emergency motion. We had to have a hearing on whether she could go back into the house, which, number one, she had the right to under the prenup, and number two, she had been living there. She needed temporary use of the house. Judge Houston granted her motion. Unfortunately, it took a month and a half to get the order signed. In the meantime, husband continued doing things throughout this case until the court finally ruled on his right to film. He sent cease and desist letters to her employer, who were scared and skittish, and it had a chilling effect on her ability to film in the home. The court order did say she has temporary and exclusive use and possession of the house, which I assume meant she could film in the house, and I thought most people would assume that. But because her employer didn't do that and didn't let her film in the house, we asked the court to amend the order. We filed a motion, which you'll see further down, to amend it and to allow her to film the house. But I'm going to skip these things. These are all just things that cause our client to spend money. Finally, in June of 2024, we filed our motion. We then filed our motion, somewhere here. We filed the motion, when he wouldn't let her film the house, then on May 20th, 24, we filed an emergency motion to ask the court to simply clear it up and say, of course, when she has temporary use and exclusive use of the house, she can film in her house. We'd offered, she wouldn't film in his private areas, in the bathrooms, anywhere, just to be in the house. She's on the Real Housewives of Atlanta, and he interfered with that. And this conduct is relevant not just to the enforcement of the prenup, it's relevant to fees. It's also relevant to his credibility when he comes in and says, we don't know what he's going to say about the situation, but his credibility is certainly suspect. He's got animus, he's got anger, he's got frustration with her, and he's done everything he can to hurt her financially and professionally. When the court said, after all these discovery motions have been filed, come for a discovery conference, which is what the court rules suggest, we did. And if Your Honor might recall, I recall vividly, afterwards when Your Honor said, look, you've got family court discovery. That's 3 years. That covers a year before the marriage up until the current time. You can exchange that, we exchange that, and that's the limit of what you're going to get. That's all you need after all of the disclosures and everything that I've seen. That covers it sufficiently for me. Opposing counsel said, well, then I want to hear it. And Your Honor said something to the effect of, well, then what's the point of the discovery conference? You got my guidance. So they had a hearing on it. Then we had a hearing on August 21st. Then Your Honor entered an order the next month. They appealed it. They filed another amendment. We opposed the appeal. The appellate court granted review. They filed the application. We opposed it. Then they denied it. Then they filed a motion for reconsideration of the appeals court denying it. The appeals court denied that. Then Your Honor granted our motion to film in the Maryland residence. Unfortunately, the season was over. Mr. Guobadia had accomplished his purpose, and the real relevance for why I'm mentioning that in opening is, again, his credibility. His purpose is to scuttle her success, whether it's revenge-oriented, whether it's anger, whatever it is. It's not based on sound legal reasoning. After Your Honor ordered that she could film in the house, they filed a motion to vacate Your Honor's order. Your Honor set a hearing. We opposed it. Then they asked for in person on the prenup enforcement. Your Honor didn't vacate the filming order. They filed a motion to do in person. Your Honor granted in person. We would have had the case finished on February 25th or 26th when the hearing was scheduled, but they wanted in person. Mr. Guobadia came in to the country, and again, Your Honor, talking about disclosing documents, we've written opposing counsel. We've asked verbally for any immigration orders, deportation orders. We've not been provided them. We'd asked again that they produce them, and again, we thought about subpoenaing them and noticing to produce, but we didn't want to get into another discovery dispute. I can ask more cross-examination, but it's our understanding from our client's testimony that he's previously had issues with the immigration authorities. He's previously been deported. He's used various names. His credibility is suspect, and we expect that the deportation orders would relate to that, similar to a criminal conviction if we had those orders. If they're not producing them, then Your Honor, I'm sure can rely on the law that says one who has the ability to prove a position, prove a fact, and doesn't produce it, then there can be an inference against them. I'm concluding shortly, Your Honor. Your Honor, we set it again for April 30th. They filed another motion for continuance. Your Honor granted it. They, and here we are. That's enough with that. Bottom line is, enough is enough is enough, Your Honor. This should have been, for those of us who practice family law, a straightforward, over and done divorce. The whole reason you sign a prenuptial agreement and you get good lawyers to sign and execute the prenuptial agreement is to avoid everything that's happened in this case. Every single thing. They predicted their divorce. They knew there was a possibility of being divorced. They were smart business people. They negotiated a prenuptial agreement. His lawyer drafted it. He negotiated it. There was full disclosure. Nothing has changed. Our client's income has gone up a little.
Okay, y'all, so that clip stopped, but I do have another one. So I'm gonna just answer some of y'all questions before I put up the next clip. So the reason why I said, was the judge biased, is because the judge enforced the prenup. But with regards to the prenup, if you enforce it, you have to enforce the entire thing. The judge didn't do that. The judge enforced it, most aspects of it, but not everything. So this is what I learned in court, and I didn't know this. That's why I'm really glad that I went. And somebody asked, was there any other YouTubers? There was nobody there. You hear noise. Y'all could kind of hear noise. That's because there were interns coming in, but it was only me, the judge in court. They were on the screen. Then obviously you had the bailiff, and then you had interns, but it was nobody else there. Like literally, when I left, it was 7 something, and I was so freaked out because I was like, "Dang, is anybody else in here?" So it was really weird. So this is why I said, was the judge biased? So in the prenup, it said that Porsha could not film in the home. This is what it says in the prenup. The prenup says, In order for her to film in the home, she has to get Simon's permission. The prenup also says that she cannot film any parts of the residence. It says she cannot film any parts of their life. She cannot talk about him. She cannot talk about his children. It says that in the prenup. So that's why I'm like, is the judge biased? Because if the judge is going to enforce the prenup, then he enforces the prenup. But it seems like he enforcing some of it, but not all of it, because it says this in the prenup. So that's why I'm like, was the judge biased? Now, what it also said in the prenup, and the judge didn't even care about this from my standpoint, and I kind of feel like they probably did it to each other, but in all honesty, I don't remember everything that everybody said. But Simon's attorney brought up clips in which Porsha actually, was calling Simon a slithering snake, and she basically referred to him as a criminal. Now, it said in their prenup, you cannot do that. So that's why I'm saying, is the judge biased? Because if you're going to enforce the prenup, you have to enforce the prenup. So Simon's attorney even said, if you are going to enforce the prenup, what I would like to ask you to do is remove the stipulation, because the judge gave an order that said Porsha could film in the house. But the reason why you really don't see her actually filming in the house is because Bravo been sued so many times. They don't want to be sued again. So they're just not doing it. So that's what I'm saying. Is this judge biased? Because it seems like he's doing some of what he wants to do, but then none of what the other party is asking. So in all honesty, to enforce the prenup is to enforce the whole thing. Like, you can't chop it up and say, oh, okay, well, I'm going to do this. And then, when Simon's attorney said, well, what about the filming in the house? He's like, well, I'm going to let her. I'm just going to keep my order as it was. So it's like, if you're going to enforce the prenup, then you have to enforce it all. So let's also talk about this issue. And I have to admit this, before I went to court, I didn't know that Simon agreed to these things. So the fact of the matter is, he agreed to this. Now, I get it that now there's other circumstances that's coming up, but the judge was like, bro, you agreed to this, so therefore you agreed to it. So the judge didn't seem like he really cared. And I kind of picked up on that all along and through the trial. Because one of the things the judge said is, listen, y'all negotiated this prenup for like a year before y'all got married. So they dated for a month and got engaged after a month. So technically, they started working on a prenup like a month later. So the judge was like, we're not really not going to enforce the prenup because y'all signed it. But what I'm saying is, the judge biased? Because if you're going to enforce it, enforce it. But you're enforcing it, but you're saying, okay, well, I'm going to enforce the prenup, but Porsha can do this or she can do that. But it says that in the prenup, it says no cameras, that, she can't film any part of their life without prior approval. And the judge didn't care about that.
$4 or $5 million at the disclosure of the prenuptial agreement, and they've gone up maybe to 7 or 8. I'll see what her testimony is, but it's something around that. He disclosed on his schedule and on his financial affidavit that was filed in this case, and up till today, that his net worth is well over $300 million. So his net worth hasn't changed. His income hasn't changed. Her income, I don't think it's changed. It might have gone up slightly. We'll see, but it's not anything that would change or dramatically affect or this prenuptial agreement. They've had the discovery. The only other thing is, was there fraud or duress? A year of negotiation? That's not fraud or duress. He drafted it, good lawyers, that's not fraud or duress. Has circumstances changed? Nothing's changed, except I anticipate what he's going to argue, and what I see in his newest pleading is that because he's in Nigeria, then he's going to have less money, he's going to make less money. Well, I don't know why he's in Nigeria, and I've got to imagine, and the court's got to presume, it's because of his own doing. ICE, if he's going to say ICE deported him illegally, or the country deported him illegally, that's something he takes up with them. But somebody's made a determination he shouldn't be here. But there's been no evidence, no proof, nothing that he's not able to earn the exact same amount of money, that he doesn't have the same wealth, that he doesn't have the same assets. Finally, and most importantly, Your Honor, is the house. Our understanding is that Mr. Guobadia has, during the divorce, transferred all of his assets, his liquid assets, overseas, that there's nothing really here in America. He has stopped paying the expenses of the house. The prenuptial agreement requires a few things. It requires that she give notice of whether she wants him to buy her out or she's going to buy him out. She's given that notice. She's got 6 months, I think, or 36 months, whatever it is, to get an appraisal and either buy him out or sell it. She's exercised that option. She's entitled to live there, and he's supposed to be paying the carrying costs. The only reason this house has not been foreclosed, and you hear from our client, is because she's been paying the bills that he's required to pay under the prenuptial agreement, Your Honor. That's his responsibility. On paragraph, let's see. So on page 16 of the prenuptial agreement, there's a number 2 in the middle of the page. Upon an event of dissolution, that's defining divorce, Porsha shall have the right to remain and occupy the residence, including up to the date the marital residence is sold, if the marital residence is sold. Upon the event of dissolution, Simon shall physically vacate, i.e. cease living in, the marital residence within 30 days. Provided, however, Simon shall be permitted to leave his personal property, the marital residence, for a period of up to 6 months from the event of dissolution. The paragraph before that says that the carrying cost shall be paid by him. Your Honor can read it, it's in evidence, but part of that says, Simon, in bold letters, shall timely pay the marital residence carrying cost until the earliest of the following events: the closing of the refinancing transaction, the closing of the sale of the marital residence, or the expiration of 36 months measured from the date of the event of dissolution. Once Porsha completes refinancing, the refinancing transaction, Simon shall have no further obligation to pay the marital residence carrying costs. No event shall Simon have any obligation to pay any of the marital costs after the 36 months. And I bring that up, Your Honor, because they also didn't follow part of the prenup about transferring it into a trust. He was supposed to transfer it into a trust, and then it was supposed to be transferred to her. At this point, because he's out of the country, because we don't anticipate any cooperation, we're asking the court under its equitable powers to simply execute the order we submitted to the court to transfer the house to our client and let her effectuate the terms. She will give him his half. There's also the cost that he hasn't paid, allow her to deduct those. Instead of, I don't want an order that says he's got to pay her this back due and this back due that. Whatever he owes her, we expect the evidence is going to show there's maybe $1 million, $1.5 million left in equity in the house. This delay has hurt everybody, but it's hurt her the most. Had she refinanced it, had she been able to refinance it at the start of this divorce, Your Honor, and we all recall, unfortunately, how low interest rates were and how easy it would have been to refinance. She's been carrying this and she's been paying the mortgage. And my understanding, my client will clear it up, is that he had somebody else pay some expenses, and now those people get paid a fee or an interest or a heightened amount for having taken care of some of those bills related to the house. Whatever she's incurred as a result of his failure to pay, she just wants to be the bigger person. She's taking care of things. She's been the grown-up. Your Honor will recall at the last hearing, it was clear she said, and we asserted, that he owes about $5,000 a month child support, or $2,500 a month child support for other children. Our client learned that and paid that because she felt bad for the other children, because he hadn't paid that as well. So anything that she's paid that he was required to pay under the prenuptial agreement, we simply ask Your Honor, award her the house, make her do whatever she's supposed to do under the prenup, which is to give him his share when it's time, when she refinances or sells it, less whatever she was supposed to already have not paid, that she had to pay on his behalf or on their behalf, so the house wasn't foreclosed. Thank goodness for Porsha Williams maintaining the house, fighting this battle, and Your Honor, thank goodness she had the funds to afford counsel. She still owes us money, but we couldn't have tolerated a $250,000 bill thinking that one day Judge Eaton is going to order Mr. Guobadia to pay it, and Mr. Guobadia, who's overseas, is going to have a court order to pay 𝐿 $250,000, and we would not have banked our fortune on that. This is a fortunate situation that she has the money, and it's not just the money she's paid us, the time away from her career, the damage to her career. She suffered losses. We're just asking the court to enforce the agreement, let her take the house, or transfer title by virtue of a judicial deed, instead of requiring Mr. Guobadia to sign documents, which we know will be back here again for enforcement issues, and just execute the order that we proposed to the court. And like Your Honor said, since we're out of court, consult with my co-counsel very, very briefly. If I can, instead of Ms. Hayward James telling me about the vehicle, may I just have her address the vehicle, Your Honor?
That's fine. I mean, just keep in mind it's an opening, so you know.
Yeah, I just want to put the court on notice. And Ms. Hayward James, if you'll just alert the court to the vehicle issue instead of explaining to me.
As it relates to the vehicle, under the prenup, the 2021 Rolls-Royce, the title was to be, upon divorce, the full balance owed on the vehicle was to be paid off, with the title being transferred to Ms. Williams. So in our proposed order, we have included that language, and we've gone ahead and put the vehicle identification number as well as a title number in there, so that it hopefully facilitates the transfer of that property in the event that there is no cooperation on the other side. And to our understanding, the registration on that vehicle has not been paid. We're not sure that the lease is up to date. So there are a number of issues with that as well, which we've included within the language of what would be owed from, if anything, from the equity remaining in the home.
Okay.
Okay, y'all. So I wanted to show y'all those because after this, I'm going to go through the videos and, you know, redact it or whatever. I'm going to jump into Porsha's testimony. Now, somebody was saying Porsha paid his child support and Porsha had paid the mortgage. So I feel like at this court hearing, they were saying anything. And let me just tell you why. Porsha said she paid the mortgage, but she didn't know how much it was. So I'm like, girl, did you pay it or not? So the fact that she didn't know how much it was a red flag. Now I get, she said she didn't pay it. Somebody else paid it. I don't give a damn who paid it. It came out of your account. So although you did not pay it, you got a good idea of how much they paid. Porsha, you are not Oprah Winfrey. You ain't damn Tyler Perry. Your money ain't long like that you ain't adding it up, sweetheart. So the fact that she didn't know how much it was made me think she's lying, because she said that, you know, Simon stopped paying the mortgage, which we already knew. I mean, anybody could have figured that out. But then she says, well, I had to pay it for the last 3 months. And when asked how much, she didn't even know how much it was. And then the specific answer was, you know, how much did you pay? Obviously, she would have, you know, been paying the utilities. What I believe she did is pay the utilities, the water. You know, in a previous filing, Porsha's own attorney said she didn't even know who the mortgage company was. So it's very interesting that she paid the mortgage and didn't even know how much it was. Now, she mentioned that she had paid Simon's child support. So I'm assuming she meant maybe when he went into custody and, you know, I guess one of his kids or child mother was concerned and she said she paid it. I don't know if she paid it or not. Maybe she did, maybe she didn't. But this is the thing that I feel like I don't know how she's going to do that. I don't know if y'all are familiar with jumbo loans. Probably not, because I mean, if you don't live in a house worth $810,000, you probably don't know what it is. So a jumbo loan is for mortgages in excess of $806,500. So anybody who house is worth that much, if they didn't pay cash for it, they have a jumbo loan. So what y'all need to understand, I do know a little bit about mortgages because I used to be a loan officer so many moons ago. I used to have a mortgage company. So that was like so long ago. So one thing y'all need to know about jumbo loans is the interest rate is not like a regular interest rate. It's not a low interest rate. If y'all remember in this video, Randy Kessler, her attorney, is talking about, oh, you know, if he would have, you know, transferred the deed before, then she could have refinanced it when the interest rates was low. The interest rates is going to never be low for a jumbo loan. So what I've also people been saying, and, you know, somebody reached out to me that's friends with Porsha, said she got bad credit, which makes sense because Porsha said well, she didn't say it, but they said in the prenup that it allows for Porsha to stay there for 36 months. Now, Simon agreed to this. Simon signed it. The reason why he agreed to let her stay there for 36 months was for 2 reasons. She quit her job. She was not working. So the 36 months of him paying the mortgage and paying the bills would give her the opportunity to kind of get on her feet, start back working. We all know, when you buy a house, you got to have tax returns. That's going to substantiate the income, right? Because y'all know she quit her jobs, right? So where's the income and the taxes to be able to substantiate her buying a big purchase like that? So it makes sense why he gave her the 36 months. And he said it. He said that. Like, he testified. And like I said, I'll let y'all listen to his testimony. He testified and said that was the reason. So it makes sense. So then it will leave us to wonder, if she needed 36 months to get on her feet, how in the hell is she going to refinance this house? You see what I'm saying? So, okay. Somebody put in the chat, what about her own house? That is a great question. Because she was asked on the stand about her property. What she did say is that she was able to get a loan, but I don't believe that either, because she didn't even know nothing about it. Now, listen, I done had a loan for over a year now, and I have to keep updating it because I just haven't found anything. Now, I bet you I know who it's through. So she did not know anything about it. So it led me to believe, girl, is this a lie? Like, you may not know the interest rate because the interest rates continue to change, but you'll at least know the bank. She didn't know nothing. So I don't even believe she has a loan. But what she did say is, which made sense, they told her she would have to sell her other property. So you see what I'm saying? She has a lot of things that she needs to do. So she would actually have to sell a house to buy a house. How's she gonna do all of that? That's a lot. So keep in mind, y'all, Simon is supposed to pay her $40,000 a month for each, I guess, month that they've been married. So he got to pay that. He's supposed to pay the mortgage. He's supposed to do this for 36 months. So if Simon stops paying now, what y'all think gonna happen? Nothing. Because in this video, they said that whatever Simon had, he transferred it out of here. So it's nothing here that she can take and garnish, a garnish or whatever. It's gone. So if he don't pay, I mean, they done kicked him out of the country at this point. So if he doesn't pay, how does that hurt him? I mean, he can't even come here, and you know what I mean? So I don't know. Will he pay? I have no idea. Thank you so much. So those are some of the things that I wanted to touch on. So so is the divorce final? Yes. So it does not show up online. What happened in court, I don't know if I told y'all this, but I was literally there till about 7:15, and we were, how y'all see them on the screen. You see the big screen. Everybody, it went blank, and then so they have that screen and two desktop computers. Everybody went blank from the big screen that y'all see right now, and then I could hear them on the other screen. So I had to stop my recording and move it over. And then in like 30 minutes, every screen went blank. And I told the judge, I said, I'm out of here. Like, this is our sign to leave. So as the judge, he had gave his ruling, everybody disappeared, so that the computer started updating and it just turned off. So I was just like, oh my gosh. So what the judge did is he granted them a divorce. So he did the prenup and he did the divorce. So it's done. But like I said, it doesn't show up on the computer because the judge wants the attorneys to prepare the order. So the attorney's going to get together, prepare the order. Simon's attorney was concerned that Porsha's attorney would put some salacious stuff in there. So obviously the judge is going to look over the order. They're going to go back and forth. So it doesn't show up as of yet. I would say give it some time and it will show up online. But the order, it's not done. They didn't finish to 7 something. And I'm assuming that at some point they had to reconvene today because the computers went off. The computers went off. So like I said, I have some more videos that I'm going to, I got to bring up here, y'all. It's a whole process. I actually have a separate phone. So I actually have this as my personal phone, but then I went and got this. But what I learned is I didn't have an Apple ID with my new phone. So I had to go to the Apple store, child. They had to hook me up because I didn't even know how to do that. So now I got, the video. I got to just, translate it over. So it's a process. So like I said, this was, Porsha's attorneys kind of opening statements, and then what you guys will hear next. Let me see what the next video is. I think the next video that I'm gonna put up is actually it's going to be Simon's attorney. She's gonna get into her opening statements. I'm gonna skip because there's a few people that came up to testify. I probably just don't even include them, but I'll also include Porsha testimony. I think I'm going to do Porsha's testimony in one video because Porsha's testimony is like an hour. So if I include Porsha's testimony with the opening statements for Simon's attorney, it's going to make the video too long. So the next video I'm going to do, you'll hear Simon's attorney and she'll do her opening statements. But then Porsha's, when Porsha testifies, I'm just going to have to make that one video because it's like an hour long. I just, don't like to do videos that's over an hour because people don't want to watch it. So y'all got some more questions. The mortgage needs to be paid 3 months late. How is she going to pay that mortgage? Here's my deal. I think, some way Porsha thinking he gonna pay, and maybe Simon paid. Maybe he will. I don't know. I mean, if Simon pays, Porsha won. But the part that I didn't know, that I'm just learning, I initially thought that Porsha was trying to just take the house. Wait a minute. It's different when you and him agreed to it, and he said that you can have the house. So I guess I can kind of understand where she's coming from, but I don't know. I'm not going to put all my eggs in one basket and, be dependent on anybody, but we have to see, is he going to pay? I have no idea. He in a whole nother country. Simon testified that his income is different. The judge didn't believe it. The judge did not believe it because think about it, y'all. They even said this, in these couple of videos. Simon said that his income was like 360 something million. I mean, and the judge was like, I understand, you had been in custody of ICE, but how do you lose 360 something million? Which I was like, he got a point. And then they also said, that Simon did not bring anything that showed that he had lost everything. But then if you think about it, Simon was, let me tell y'all the date. Simon was actually released from ICE custody a week ago. So he was released, today is the 12th. He was released on the 6th or the 7th of last week. So I don't know, maybe he just didn't have time. I mean, the man was just released. I have no idea, but that's it for today. Like I said, I'm going to upload some of the other videos so y'all will be able to see. I just pretty much at this point want y'all to kind of see what happened in court. So I'll be uploading those videos. And if y'all don't have any other questions, I will see y'all later.
She don't miss nothing, got the scoop on lock. Spilling all the tea while it's still too hot.